you everyone for joining me today. I'm Shanna Welsh-Levin with So Cal Realty Law. I am your Southern California real estate attorney. So Cal Realty Law helps real estate investors and real estate professionals. And so today I'm going to tell you about a little bit of changing that will happen. Lately, my day-to-day efforts have been to assist landlords in trying to avoid the eviction process and handle difficult situations with tenants without being able to really threaten them with eviction or proceed with evictions in many cases. So we've also been working to provide landlords with strategies so that they can plan for the eventual resolution of difficult tenant situations. And so here we are today with today's seminar that landlords need to know what to expect in October 2021. So what is going to change and what is going to stay the same? I am making some presumptions today that a big change is going to happen as of September 30th, 2021. My presumption today is that the California Eviction Moratorium is going to expire, and therefore we will be able to proceed with many more evictions in the coming months, but there will be a lot of restrictions. There will still be a lot of legal issues that take us outside of the norm due to COVID. First and foremost, we'll get this one out of the way. The San Diego County ordinance that was enacted in June of 2021 has expired. It expired on August 10th, 2021. In case you weren't familiar with it, in May, the San Diego County Board of Supervisors voted to enact this countywide ordinance stopping residential evictions of every kind. And when that became effective June 3rd, 2021, really most evictions just stopped dead in their tracks. And those that were trying to proceed were postponed or dismissed from the court. So it stopped pretty much all evictions except for what we call the SB 91 non-payment of rent evictions. Those evictions were tenants who failed to provide hardship declarations when served with notices. And then it also allowed to go forward any evictions against a tenant who was an imminent risk to the health and safety of other occupants at the particular property where they were living. And so there was a queue of cases that had been filed prior to the ordinance taking effect, and the court was postponing those cases till after August 14th, which originally when we calculated when the ordinance would expire, we thought it would be August 14th or August 16th, and it actually was said to expire August 10th. So those cases that were postponed till after its expiration, many of them have proceeded. The interesting thing about that ordinance is that it sought to invalidate every notice and every unlawful detainer that was issued or filed prior to August 10th, 2021. We know for certain that the court was enforcing the ordinance against notices and cases filed during the ordinance period, which was June 3rd, 2021 to August 10th, 2021. But it's still unclear what the retroactive effect is. It's my understanding that notices and cases filed before the ordinance was enacted were able to move forward after it expired. And my office does not have any cases in that particular posture with the court. So we don't have any personal experience. I don't have any personal experience with those kind of cases, or whether they're being challenged in the retroactive, with the retroactive idea. So I've been relying on my colleagues to publish bad results or to, talk about them in their webinars or post them on social media. And I personally have not heard of any cases that were filed prior to June 3rd, 2021 that were dismissed for non-compliance with the ordinance. Primarily what I know were being dismissed was those cases that people were trying to move forward during the ordinance, but not prior to it. I was also made aware that tenants' attorneys were filing motions for judgment on the pleadings. for any cases that did not comply with the ordinance during that period, and that those motions were being granted. Let me just make sure everyone's muted here. Sorry. Okay, so those motions were being granted, and that's how most of those cases were being dismissed. Now that the ordinance has expired, the court can still enforce the ordinance against cases that were notices that were served during the ordinance period and cases filed during the ordinance period. However, it's unlikely that it's going to have any long-lasting effect on cases moving forward. Okay, so I'm not sure if you guys are seeing the same view as I am, but I'm just moving the view around as well. So the California Eviction Moratorium expiration date is scheduled to be September 30th, 2021. The California Eviction Moratorium is called the Tenant Protection Act of 2020 or the COVID Tenant Protection Act of 2020. And this began officially in August of 2020. It was extended many times. First, at the end of 2020 into February. Well, actually, I think the first extension happened in February, and then it was extended again in June until this new September 30th date. And so I am making a presumption today that it is unlikely to be further extended. And the basis for that presumption is because the legislature is in recess, and they will be in recess until after the expiration of the moratorium. So it would require an emergency act by the governor to extend it further at this point. And I've consulted with other sources, other colleagues who also agree that it is very likely not going to be further extended. I'm still holding my breath, but if it does get extended, I guess what I'll have to do is send you all an emergency bulletin and do maybe another webinar to correct some of the conclusions that I have to make based on my presumption that it is going to expire. So what does the expiration mean? What is going to change and what is still going to stay the same? First and foremost, notices to tenants. Some notices will stay the same. We will continue using certain notices, and some will change. The notices to pay or quit that relate to COVID rental debt will stay the same through October 2025. So the period of time for rent that was owed and rent that is past due that was owed from March 1st, 2020 through September 30th, 2021, that's the whole COVID period of time, will have to still comply with the 15-day notice requirement. So when they passed the law, we went from a 3-day notice to pay or quit to a 15-day notice to pay or quit. So just for rent that's past due from this COVID rental debt period, you still have to use a 15-day notice. You still have to serve the COVID hardship declaration with it, and you still have to include the notice from the state of California that informs the tenant about their rights under the California moratorium. The other part that is not going to change is that the 2019 Tenant Protection Act restrictions will still apply. The 2019 Tenant Protection Act was our, if you recall, AB 1482, it was the rent cap and just cause eviction. That does not expire at any time. That's the law of the land forever and always until the legislature decides to change it. So those are those restrictions under the 2019 Act apply to at fault and no fault just cause reasons for properties that are exempt or not exempt, particularly properties that are not exempt from the 2019 Act. And that is a webinar for another time. The analysis of whether a property is exempt or not exempt from the 2019 Tenant Protection Act is a bit complicated, but just for the record, that act and all of those restrictions still apply. what gets confusing a little bit is that the 1179.03 statute, that is the 2020 COVID Tenant Protection Act, borrows the definitions from the 2019 Tenant Protection Act. So 1946.2 is referenced in the 2020 Act. And even though those restrictions expire for rent due after October 1 of this year, those definitions are still applicable to properties that are not exempt from the rent cap and just cause eviction statute from 2019. All right, what is going to change is, hooray, we will go back to using 3-day notices to pay rent or quit. It has been a long time since we were able to use a 3-day notice. Out of an abundance of caution, there were only very narrow reasons why we would issue a 3-day notice to pay or quit in the last couple of years. And so, well, since COVID started, basically. So for rent that is due October 1, 2021, and for all rents due after October 1st, 2021, you can now do a 3-day notice to pay or quit. But a new law that was enacted does require a landlord to at least attempt to obtain rental assistance first. So for as long as those funds are available for rental assistance, landlords will be expected to apply and to try to obtain the rental assistance for any non-payment of rent unlawful detainer. So what's been said is that this rental assistance requirement is a stopgap measure. It's intended to prevent a tsunami of non-payment of rent evictions from going forward, and that's particularly for the COVID rental debt. And it provides the tenants with a little bit of a waiting period before you can go forward with the eviction. It requires some additional hoops to jump through before you can go forward with non-payment of rent evictions. And it still acknowledges to some degree COVID hardship, because as part of the application process for the rental assistance, the tenant has to explain their income. They have to receive 80% or less of the average median income for their area. And they have to have some sort of a hardship to qualify. And then in order to proceed with the eviction, both tenants and landlords will have to show evidence that they applied for the rental assistance program and they were either blocked for some reason, or they are still waiting for a response. So cases may be dismissed or delayed for the failure to try to get the rental assistance. And another interesting thing that starts coming into play as we analyze moving forward with eviction cases now that the moratorium expires is that local ordinances become relevant again. Many local ordinances were less restrictive than the California Eviction Moratorium, and therefore the local ordinances were superseded by the California statutes. But for example, the City of San Diego Fair Renter Ordinance protects qualified tenants from eviction without just cause. A qualified tenant under the San Diego ordinance is a tenant who has been in the property for 2 years or more, and there are exceptions to this ordinance. But for example, one of the just causes that may be used under that ordinance to evict a tenant is withdrawal of the residential rental structure from the rental market. And that's only if all of the rental units on the premises are being withdrawn. This particular statement is less restrictive than the COVID restrictions, which was if you want to withdraw your residential rental structure from the rental market, you had to fit into one of 2 boxes. One is that the owner or their immediate relatives were going to move into the property, or 2, you were in escrow for sale to a bona fide purchaser at fair market value, and that buyer intended to occupy the property and that buyer was not a corporation. So now we get to reduce the restrictions a little bit. Okay, and so for the properties that are not exempt from the rent cap and just cause, the 2019 Tenant Protection Act, they're still restricted by many of the at-fault just cause definitions and no-fault just cause definitions, but now we get to loosen up those restrictions a little bit. So under COVID restrictions, the at-fault just causes that could be used are these. Note that you could not do a non-payment of rent, eviction, unless you served notices and the tenant didn't respond with the declaration of hardship. Any breaches of material terms of the lease that were related to COVID rental debt could be prevented by the tenant by just submitting the declaration. Assigning or subleasing was considered related to COVID rental debt and could be prevented from going forward based on a COVID hardship declaration. And so now, once it expires after October 1st, 2021, even for non-exempt properties, you will be able to move forward with non-payment of rent, breach of material terms of the lease, illegal assigning and subleasing. I know there are a lot of landlords who have been waiting for this opportunity. And so what we have to do is let October 1st pass, establish that these breaches are still happening, and then we can move forward with new notices and new evictions for non-exempt properties. Similarly, the no-fault just cause definitions, as I mentioned, were much more restrictive than the actual definitions that can now be applied directly from the Civil Code 1946.2. And so, as I mentioned, withdrawal of the property from the rental market under 1946.2, it's just this blanket statement, withdrawal from the rental market. It doesn't have to be in escrow for sale to a buyer who's not a corporation and who intends to occupy. Also, if the reason for the eviction is a substantial remodel, the definition under the Civil Code 1946.2 is much more loosely defined than the adjustment that was made by the California Moratorium, the 2020 Act, which included specific language that the substantial remodel had to be related to habitability and bringing the property up to code. And then the really good news is that in some jurisdictions, it will be possible to move forward with some no-fault, I wrote that wrong, some no-fault evictions for exempt properties. What I meant to say was some no cause evictions for exempt properties, meaning that in certain jurisdictions where there is no local ordinance and the property is exempt from the 2019 Act, a landlord may be able to proceed with an eviction without citing a just cause in their notice. It is not recommended to issue a notice without just cause. The reason for that is you set up the tenant, you hand the tenant a potential defense to your eviction. They can say that you were retaliating against them. The landlord was retaliating. They didn't cite any particular cause on their notice. So the motive for the eviction must be retaliation for non-payment of COVID debt or complaining about the condition of the property or, whatever the tenant chooses to use under that defense. So we still, as a matter of practice, as a matter of course, we still like to include a just cause in our notices, even if the property is exempt from other restrictions. All right, so the next thing that is basically staying the same is rental assistance. The disbursements of the funds from federal and state resources has been happening. I know a lot of clients and a lot of landlords who are receiving money. They're being told there's a pile of money. And now the application process is required by law. So the rental assistance programs can be accessed at housingiskey.com or housing.ca.gov, or the 800 number 833-422-4255, or in the city of San Diego, the San Diego Housing Commission website, sdhc.org. And so it's important to recognize that those protections are tied to $5.2 billion in federal aid that was intended for rent relief. It applies to people who make less than 80% of their area median income, who were financially affected by COVID-19. And they can, in California, apply for 100% of the past due rent. And now they can also apply for 3 months of forward rent. But the distribution of that money is still a problem. While the state has received applications for about $1.9 billion in assistance, it has distributed only $491 million. It's unclear exactly why that is, but according to a recent analysis of California's rental debt by PolicyLink, an Oakland-based research group, about 753,000 families are behind on rent and owe a cumulative $2.8 billion in rent. So there's still a significant problem out there, and just because the moratorium ends, it does not fix the problems that we're seeing with people, tenants not being able to pay their rent and people having COVID hardships. An update on the Federal Centers for Disease Control eviction moratorium. This has had a big change. On August 26, 2021, it was invalidated by the Supreme Court of the United States. The Supreme Court vacated the stay of the moratorium, stating that the CDC exceeded its authority in enacting the eviction moratorium. The court reasoned that only an act of Congress can create that law, not an agency of the executive branch, especially when it has not been given explicit authority to do so. In deciding to vacate the stay, the lower court, the federal court that initially enacted or proposed that the CDC moratorium was invalid, is now enforceable. So basically the decision that it's invalid is now enforceable, and therefore the CDC moratorium may no longer be used by tenants to stay evictions moving forward. Since the Supreme Court is the highest court in the nation, its decision affects every state and every court in the nation. And therefore that decision is final, unless, and this is what the court advised basically, is that unless Congress creates a new or similar law banning evictions due to the COVID-19 pandemic. So the question is, has Congress taken any action? There was some action attempted, but because of the nature of the action, it was blocked by the Supreme Court's decision. So the Biden administration, you may remember, they tried to do something. It was deemed invalid based on the Supreme Court's decision. And the legislature, the Congress, cannot act right now because they are in recess until later this month. It is likely that they will do something. Keep in mind that the CDC eviction moratorium was less restrictive than the California eviction moratorium. So until now, the CDC moratorium would not have affected us and has not affected our cases, because the California law, being more restrictive, superseded the issues with the CDC. There was some relevance and some use to the CDC declaration, and we certainly saw tenants submitting those to the court, but for the most part, they didn't have a big effect on our cases. It's likely the Congress will do something about enacting another moratorium, because studies show that evictions are linked to disproportionate impacts on Black and Latinx people, particularly women, and they have been linked to, evictions have been linked to increased cases and deaths from COVID-19. So with those statistics, I don't have the exact statistics, but with proof that that is the case, it's likely that something else will be done. Something that stays the same is that landlords can still increase the rent. There was really never a restriction under the California Eviction Moratorium on increasing rent unless there was already a rent cap, excuse me, or other limitation that applied to the particular property. So for instance, the California rent cap, the Tenant Protection Act of 2019, still applied and continues to apply to all properties that are not exempt from that act. Section 8, if the landlord has become a part of that program, it will affect the ability to increase rent. And then we have the California anti-gouging statutes that prevent landlords from increasing the rent under certain circumstances. We still caution against rent increases, especially for tenants who claim to have a COVID hardship and who are behind on their rent due to COVID hardship, because it does provide an opportunity for the tenant to claim that the rent increase was retaliatory. And all of the new laws that do still exist warn expressly against retaliatory evictions and retaliatory action by landlords against tenants. So you need to be careful and look at the totality of circumstances when considering a rent increase, and make sure that you're not only in compliance with the law, but you are not raising danger of the tenant making those claims against you that you were retaliating. And on the landlord side, there is protection from liability for the landlord who temporarily reduces or makes unavailable some service or amenity as a result of having to comply with COVID regulations. And so if that's the situation, there is some protection provided for landlords. So there's a lot of uncertainty left behind, even though it's nice. And I feel like there is a lot of clarity in being able to say that the moratorium is expiring and we can move forward with something closer to business as usual than we've had for at least the last 18 months. There's still a lot of question, in particular, the repayment of COVID rental debt. So tenants who have claimed a COVID hardship and who have not paid their rent are required to pay 25% of the COVID-related rental debt on or before September 30th. And if they don't, they may be evicted. So at that point, if the tenant hasn't paid it, you can proceed with issuing notices compliant with the COVID 2020 restrictions, and then proceed with an eviction if they haven't paid the 25% by the time that notice expires. If they do pay the 25%, then they are protected from eviction for the remaining balance of the COVID rental debt through March 31, 2022. Landlords may begin to commence the legal action against tenants to pay back COVID rental debt beginning on November 1st, 2021. However, if there is a local ordinance that was enacted prior to August 19th, 2020 to protect the tenants from collection of the rental debt, the commencement of payments under state law must begin by May 1st, 2022, and the repayment period cannot extend beyond May 1st, 2023. And there is also the possibility, so there are two protections going on. One is the protection from eviction. The other is the protection from collections. With regard to protection from eviction, the state law provides that the tenants who pay 25% are protected through March 31st, 2022. But the state law also provides a window in which a local jurisdiction may enact an ordinance to continue to protect tenants from eviction. And as long as that ordinance complies with certain provisions of the COVID 2020 Act, a local ordinance may be enacted. So we don't know if there might be some local ordinances enacted to further protect people from eviction. But with regard to collections, I'm not aware of any local ordinances that were enacted prior to August 19th, 2020 that stopped collections for extending to a date beyond November 1st, 2021. So state law says that as of November 1st, 2021, you may proceed to small claims court, a landlord may proceed to small claims court to pursue that COVID rental debt. And the small claims court can issue a judgment for COVID rental debt that exceeds the $10,000 limit that you usually have in small claims court. There is no limit to the amount of COVID rental debt that can be obtained in a judgment from small claims court, but you have to wait until after November 1st. Unless there was a local ordinance that extends it beyond November 1st. And then there are limitations on that. So I'm not aware of any ordinances that extend beyond November 1st. So this interesting uncertainty kind of leads to these points. There are more points of uncertainty. Post foreclosure evictions, the COVID restrictions never applied to post foreclosure evictions. Technically, someone living in a property after foreclosure is, if they were the owner or the borrower that was foreclosed upon, they are not a tenant. If there were tenants living in the foreclosed property, if you recall back during the mortgage meltdown in 2008, in 2009, we had the Tenant Protection Act. And that federal act, and I believe the state act, have expired in their entirety. So we would assume that if COVID causes foreclosures, there might be some activity relating to protecting tenants in foreclosure again. I predict that foreclosures will begin after forbearance runs out. Many landlords have sought forbearance from their lenders, which means that they are not paying the mortgage for the time being. And lenders are providing certain plans and ways out of that forbearance at some point in the future. We would hope that they do a good job of helping people become current on their mortgages again, so that we don't have a landslide of foreclosures. But I predict that there will be foreclosure activity in the next 6 months to a year. And so we might see some tenant protections related to that. There's this proposed legislation, SB 747, which is potential relief for landlords who have tenants claiming COVID-19 related hardship, but who earn too much money to qualify for the rental assistance. And this would also help landlords who have tenants who refuse to cooperate in completing a rent relief application, but it won't be considered until December or January when the legislature is back in session and actively voting. So then the last point of uncertainty, it has been a point of uncertainty throughout COVID, is the timeline for enforcing judgments for possession of premises. The question is whether the sheriff will change their way of enforcing writs of possession. Throughout COVID, the sheriffs have not acted as quickly as they used to. And in some cases, they have taken months to enforce a writ of possession. It's unclear what their basis or what their authority is to not enforce a writ of possession after. This is when you've gone to trial, you have evicted the tenant, you've obtained your judgment from the court, you've filed your paperwork with the court, and once that paperwork is issued, the court issues a writ of execution for possession. You take that to the sheriff with the sheriff's instructions, and the sheriff used to process these in a matter of a couple of weeks. But that has been very different due to COVID. And we hope to see a shorter timeline for those sheriff lockouts now that things are changing and starting to go back to normal. The courts have not been backed up. The courts have managed to handle the caseload very well and all of the changes. And I feel bad for the judges in Department 60 having to handle all of these cases because it is complicated and there's a lot going on. It's actually interesting to sit in on Department 60 and see how the cases are being handled. They're doing a phenomenal job. All right, guys, that is all I have for you today.